Now the next part, question number 51. An unpaid seller can exercise the right of lien when he has delivered goods to the buyer, when the buyer has lawfully obtained possession of the goods, when the seller has waived the right of lien. The correct option of question number 51 is D, when the buyer has become insolvent. Now the question number 54. A seller sells undergarments which cause skin disease to the buyer. What is the liability of the seller? C. He is liable for the breach of the condition. Seller sells the undergarment which causes a skin disease to the buyer. These are a very simple question. I think no need of any explanation. Now, each of the following is not included in the definition of the goods. Actionable claims, all movable properties, growing crops, and grass. The correct answer of the section question number 52 is actionable claim is not a good. Because जब हम goods की definition पढ़ेंगे तो वहां पे actionable claim को include नहीं किया गया है. Now, the question number 53. Which of the following is not a statement is not correct? Condition and a warranties are a stipulation in the contract of a sale. A stipulation as a warranty may not be treated as a condition. Condition is a stipulation essential to the main purpose of a contract. And the last is your warranty is a stipulation collected to the main purpose. The correct answer of our question number 53 is B. A stipulation as a warranty may not be treated as a condition. Now the question number 55. Which of the following is not an exception to the doctrine of a nemo debt quod non habet? इसका तो सबको पता है कि इस डॉक्ट्रिन में इसका अर्थ मीनिंग इसका इतना सा है कि कोई भी आदमी जो है जिसका उसके पास टाइटल नहीं है, अथॉरिटी नहीं है, वो उसका टाइटल किसी और पे कन्फर नहीं कर सकता. चोर जो है, चोर ने अगर कोई प्रॉपर्टी थेफ्ट की है तो वो जो है उस प्रॉपर्टी को किसी और पे उस प्रॉपर्टी का टाइटल ट्रांसफर नहीं कर सकता. तो इसका एक करेक्ट आंसर है आपका सी. नाउ द नेक्स्ट क्वेश्चन. हु अमंग द फॉलोइंग इज अ पार्टनर? इसमें जब हम पार्टनर की डेफिनेशन पढ़ेंगे तो इसका करेक्ट आंसर सीधी सी बात है. अ पर्सन शेयरिंग द प्रॉफिट ऑफ अ बिजनेस carried on by all or any of them is a partner. Now the question number 58. Which of the following is not an essential ingredient of a holding out under section 28 of the Partnership Act? तो जो the following is not an essential holding out जो है under section 28 में है, इसकी स्पेसिफिकली अगर आप जब डेफिनेशन पढ़ोगे तो इसका सीधा सीधा करेक्ट आंसर जो है रिप्रेजेंटेशन विदाउट नॉलेज. क्वेश्चन नंबर 58 का आंसर रिप्रेजेंटेशन विदाउट नॉलेज. कोई भी नहीं है, तो सिंपल डायरेक्ट क्वेश्चन है. इसलिए I recommend again and again you have to be very strong in BIHAR Act language. Which of the following is not correct about a minor? He cannot become a partner. He can be. ये तो I think one of the famous question. If I am not wrong, section 30 I think of the Partnership Act. And the correct option is he is personally liable for the act of the firm. इसके लिए वो it is the only one exception कि वो liable नहीं होता. वो partner हो सकता है, वो firm में फर्म का जो प्रॉफिट है उसको शेयर कर सकता है. दिस इज ऑल. नाउ द क्वेश्चन नंबर 57. अ पार्टनरशिप इज अ पार्टनरशिप एट विल. पार्टनरशिप इज अ पार्टनरशिप एट विल. वेरी इंपॉर्टेंट क्वेश्चन, बेसिक डेफिनेशन क्वेश्चन. एंड आई थिंक नो प्रोविजन ऑफ, जब आपका टाइम लिमिट नहीं देके रखी होती है ना तो वो पार्टनरशिप बिल आती है. और दूसरी कंडीशन ये है कि व्हेन अ प्रोविजन इज मेड फॉर अ डिटरमिनेशन ऑफ अ पार्टनरशिप. ठीक है, तो ये जो है आपकी इनमें बोथ ए एंड 57 इसमें नहीं सॉरी या तो ए सही है या तो बी सही है. दोनों चीजें नहीं चाहिए. ये आपका जो पार्टनरशिप एट विल की डेफिनेशन के हिसाब से इधर ए और इधर बी आएगा. नाउ द क्वेश्चन नंबर 60. व्हिच ऑफ द फॉलोइंग इज नॉट अ कंडीशन प्रेसिडेंट फॉर फाइलिंग अ सूट अंडर सेक्शन 69 ऑफ द पार्टनरशिप एक्ट? जैसे ही आप कुछ इसमें डेफिनेशन पढ़ोगे तो इसका जैसे डेफिनेशन में सी द इन्फोर्समेंट ऑफ एनी स्टैट्यूटरी राइट, दिस इज नॉट अ कंडीशन प्रेसिडेंट. When a negotiable instrument is dishonored, the liable party pays a compensation to, I think this question is a very easy, holder. Which of the following is not a correct with regard to the presentment of acceptance? इसमें क्वेश्चन ये पूछता है कि which of the following is not correct with regard to the presentment for acceptance में क्या जो है गलत है उसके बारे में. Only holder of the bill or his agent can present the bill, ठीक है. Drawer himself can present the bill, ठीक है. If the bill has been negotiated before acceptance, ठीक है, the bill cannot be presented to the legal presentation case of a death. Case of the bill cannot be presented to the legal presentation in case of a death of a drawee. Now, which of the following is not an example of a negotiable instrument? I think everybody knows the answer of this question. Very, very easy question. Share certificate is not your example of the negotiable instrument act. Negotiable instrument, sorry. Which of the following statement, question number 65. Which of the following statement is correct in relation to the bouncing a check? Offense of a check bouncing is a compoundable offense. ये बोल रहे हैं कि which of the following statement is correct in relation to the bouncing of check. तो इसका तो सीधी सी बात है कि offense of a check bouncing is a compoundable है, ये पैसे देगा तो compound हो जाता है. Correct? A draws a check in favor of a B, a minor. B endorse it in a favor of C, and C endorse in favor of a D. The check is not. Which of the following is not correct about the liability of the parties? देखिए, ये आपका जब माइनर जो है, जब माइनर जहां पे आ गया तो उसको लाइबल हेल्ड किया नहीं जा सकता. वो लाइबल सिर्फ एक ही चीज में लाइबिलिटी उसकी शो होती है जब जो है वो इसेंशियल commodities में उसको कुछ दिया होता है. तो C and D can claim from B. This is your is not correct about the liability. C जो है देखो आपका A से क्लेम कर सकता है, D can claim C and A, but C and D cannot claim from B. C and D can claim from B. ये ठीक बात है, वो क्लेम नहीं कर सकते. पर ये जो करेक्ट आंसर इज योर A of question number what we are discussing, question number 63. Now it's a very easy question. An application for prevention of operation and mismanagement in a company should be made to the OBS, National Company Law Tribunal. A director appointed to fill, question number 69. Director appointed to fill up a casual vacancy will hold office. ये तो जैसे ही आप डायरेक्टर्स की अपॉइंटमेंट या उसके प्रोसीजर पढ़ोगे तो उसमें आपको कंपनी लॉ में ये वेरी वेरी इजी क्वेश्चन आई थिंक up to the date of expiry of the office outgoing director. For question number 67, for dissolution of a company, the tribunal shall pass an order. These are a very simple question. I think each and everybody is well acquainted with this question because very simple mean to say it's just a weird language. When affairs of the company are completely bound up. Now the question number 70, match list 1 with the list 2 and select the correct answer using the code. ये है आपका करेक्ट ऑप्शन आएगा इसमें इंडोर मैनेजमेंट, Salmon versus Salmon corporate personality, Carulo majority. Correct option is your A. If you guys want a little discussion about this question and any question, comment on my inbox box. I definitely give you the detailed idea. Which of the following statement is not correct? A company cannot have a more than one manager at the same time. 68 का आएगा आपका, company can have a more than one manager at the same time. This is obvious. Answer question number 68. Answer is your B. The Indian Evidence Act 1872 has been divided into array. Such an easy question. I think everybody should know about this. What is the answer of it? Just think in your mind and try to answer. There are a three part. Correct. Electronic record in a proper custody give rise to a presumption as to the digital signature to be affixed by that particular person under section 98. 5-year-old 90, section 90. A prosecute B adultery, and this is after the amendment, IT Amendment Act. A prosecute B for adultery with C is by, B denies that C is by, but the court convict B of adultery. Afterwards, C is prosecuted. This is a very well set illustration of section 42, I think, of Indian Evidence Act. If I'm not, let me check. I will tell you. The question number 72 I'm talking about. My Indian Evidence Act. Indian Evidence Act. If I'm not wrong, 43. This is the example of 43. तो 43 के हिसाब से ये irrelevant. आप जैसे ही इसमें 43 सेक्शन देखोगे ना, उसमें इलस्ट्रेशन देखी रखी हुई है, irrelevant होती है. क्यों होती है, इसके लिए डिटेल्ड आपको डिस्कशन करना पड़ेगा. अगर आप चाहते हो तो देन प्लीज कमेंट. नेसेसिटी रूल as to the admissibility of evidence is contained in 31, 32, 60, 61. नेसेसिटी रूल आई थिंक 32. नेसेसिटी इसलिए ना क्योंकि अब डाइंग डिक्लेरेशन है, ठीक है ना, तो वी कैन नॉट क्रॉस एग्जामिन, तो इसलिए अब वो जरूरत है कि उसको जो है माना जाए, तो इसलिए वो नेसेसिटी रूल वहां पे अप्लाई होता है. लॉ ऑफ एविडेंस इज अ सब्सटेंटिव एडजेक्टिव. आई थिंक बोथ ए एंड बी. 73 an adjective law. Sorry, an adjective law. It's not substantive. Actually, I did little confused. Section 105 of the Indian Evidence Act applies to. Section 105 of the Indian Evidence Act applies to criminal trial. इसमें section 105 of the Indian Evidence Act actually इसमें बात होती है कि आपकी जो exemption है क्रिमिनल केस में, जो burden of proving that case of accused come within exception, तो वो क्रिमिनल के ऊपर होता है, जो accused है उसके ऊपर होता है. तो correct options of section 76 is A. Now, which of the one of the following is not correct? No. Hostile witness 154, ठीक है. Burden of proof has to the owner बिल्कुल 110. Refreshing memory, ठीक है. Professional communication. तो ये 123, 124 में नहीं है. Wrong option is the correct answer of a section question number 77 is D. The term victim is defined 2WA. Everybody knows. Now, question number 78. Classification of the offenses is given. First schedule, very stated question. Every person aware of the commission of an offense punishable under following section is bound to give information thereof to the also 498A 303 punishable arrest the police officer. Basically question क्या पूछ रहा है कि every person aware of the commission of an offence punishable under the following section is bound to give मतलब कौन सा ऐसा ऑफेंस अगर हो जाए जिसकी इंफॉर्मेशन देना जो बाउंड हो जाता है बंदा मैजिस्ट्रेट को या पुलिस को. दैट इज योर 302 murder. Very easy question. I think each and everybody is well aware about this question. It is mandatory to produce the person arrested before the magistrate within 24 hours. Correct answer is your 57. Direct question. I think under the section 167 of the CRPC, the magistrate can authorize the detention of a total period of 90 days during the investigating the case. Offense punishment will be the death, imprisonment, all of the above. I think. मेरे हिसाब से D is the correct answer, and the answer key is also showing the correct answer is D. Just go through the section 167. Very easy. All these option with death, all these options with death, with imprisonment for life, with imprisonment for a term not less than 10 years, you will get there. So all of the above. A decision in a suit may operate a res judicata against a person not expressly named as a party to the suit by virtue. A decision in a suit may operate a res judicata against a person not expressly named as a party to the suit by virtue of. The correct answer of question number 83 is your 6. It is explanation of the res judicata. If you want to make a detailed video, comment in my box. The court may impose a fine for a default upon a person required to give evidence or to produce a document directed under section 30B CPC, and such fine. अब देखिए कोर्ट ने किसी को बोला कि आपको है एविडेंस, पर्सन रिक्वायर्ड टू गिव एविडेंस और टू प्रोड्यूस, या आपको डॉक्यूमेंट लाने हैं, पर अगर वो ला नहीं रहा है तो उसको ज्यादा से ज्यादा कितना फाइन कर सकती है कोर्ट? 30B और 30C. दैट इज योर आंसर. क्वेश्चन नंबर 84 का करेक्ट आंसर इज योर 5000. नाउ now the question number 88, the arbitrator in a case of an international commercial, this is the arbitration next question. The arbitrator in a case of an international commercial arbitration is appointed by the party themselves, the attorney general, the chief. It is actually this question is talking about the international commercial arbitration. तो जब आप इसको पढ़ोगे तो इसका करेक्ट आंसर आएगा डी. द पार्टीज भी कर सकती है या अटॉर्नी जनरल ऑफ इंडिया भी कर सकता है. ठीक है. Now, appointment to receiver has been dealt. Option is C. Order 40 में. These are the very direct question. I think you just let me tell you one thing. If you guys listening me, if you want to make a command on the Bear Act, just write down. Just write down. Just write down. This is the one thing. There is a no short tricks. The provision for substitutory service of a summon or on the defendants has been made under whenever ये उसकी बात करता है जबकि आपकी जैसे आपने समन भेजे कोर्ट ने और समन जाने के बाद भी जो है आपकी डिफेंडेंट को सर्विस नहीं हो रही है, तो ये है आपका 520. जनरली जो कोर्ट में प्रैक्टिस करते हैं तो इट्स अ वेरी फेमस एप्लीकेशन and court ask the advocates to file this application under order 5 rule 20. Arbitration and a Conciliation Amendment Act 2015 came into force. Are a very easy question. 23rd December 2015. 23rd December 2015. In case of urgent or immediate relief where leave to investigate the suit without service of a notice under section 86 of a CPC has been granted, no interim or otherwise ex parte relief can be granted. ये in case of urgent immediate relief where leave to investigate the suit without service of a notice under section 86 नहीं होना, यहाँ पे under section 80 होना चाहिए था. So no interim or otherwise ex parte leave can be granted. The decree or order made by a small cause court are divisible by the court. Very famous question. Most of the time, this question has been asked only by the High Court. Now move to the further questions. Question number 91. Article 51A was added by clause K of the Article 51A. Very, very, very important. It is Sixth Amendment. Basically, 51A में जो आपका it talks about the राइट टू एजुकेशन। तो जो भी पेरेंट्स हैं उनकी मोरल ड्यूटी बनती है कि जो आपके बच्चे हैं 6 से 14 साल तक के उनको जो है एजुकेशन दें। तो इसके बाद इसी अमेंडमेंट के बाद आपका एजुकेशन जो है फंडामेंटल राइट बना था। आर्टिकल 21 if I'm not wrong. The parliament has a power to legislate with respect to a matter instead of a list provided in public interest, national interest, central interest, interest, only the national interest. These are some direct questions, I think, no need to discuss. In which of the following case free and a fair election is recognized as a basic structure of the Indian Constitution? Indira Gandhi versus Raj Narayan. Yeah, I think everybody is very much well aware कि इंदिरा गांधी और वर्सेस नारायण नारायण के केस में ही क्यों इलेक्शन की बात हो रही है और क्यों, क्योंकि इट इज द केस जिसमें जो है राज नारायण ने जो है इंदिरा गांधी के अगेंस्ट जो है इलेक्शन लड़ा था। Court are flooded with a large number of PIL, so it's desirable for the court to filter out a frivolous petition and dismiss them with the cost in which of the following judgment. This is also a very, very famous case and the landmark case. Olico Picture Private Limited versus Premchandra Mishra. Which one of the following cases are not related to the doctrine of severability? तो इसमें तो सीधी सी बात है, मिनर्वा मिल वर्सेस यूनियन ऑफ इंडिया। आई थिंक everybody is well aware क्यों नहीं है। If you want to discuss this case, please comment in inbox. Who among the following expressed the view? Question number 93. Who among the following expressed the view that the Indian Constitution is federal as much as it is established that by we call the dual polity? Obvious, Dr. B.R. Ambedkar. Whenever you study the Constitution in a detail, so then there is a quotation which is said by B.R. Ambedkar. The law declared by the Supreme Court becomes the law of land. Think in your mind. Don't miss this question. I think 100% all of you will ready to can answer. Article 141. Correct option is C. In which of the following judgment of the Supreme Court triple talaq was declared unconstitutional? Shaira Banu versus Union of India. Gulshan Parveen versus Union of India. मेरे हिसाब से शायरा बानू वर्सेस यूनियन ऑफ इंडिया। बाकी आंसर की sometimes show that both A and B. The power of the President of India is issue an ordinance is a legislative power, executive power, quasi-judicial power. The correct answer of the question number 98 is legislative power. इसका मीनिंग समझ रहे हो आप में से? Legislative power. Because the President is also a part of Parliament. Which of the following does not find a place in the preamble of the Constitution of India? I think everybody should answer. Education of for everyone is a nowhere talks about justice की बात देखो, liberty of a thought and expression की बात होती है, justice की बात होती है, dignity of individual की बात होती है, पर education की बात नहीं होती। इसमें preamble in first instance the president can issue a proclamation of a financial emergency for a period of very important question, very important question, and it is for 2 months. Now, Professor Casey Ware said that the Constitution of India is big federation, non-federal, strong federation, quasi-federal. Correct answer of 103 is your quasi-federal. It's everybody knows why it is a quasi-federal, because it's not because it's not absolutely federal in nature. Now, question number 100: in which of the following landmark? Can you see the lots of the landmark cases that has been asked in this exam? So um, I have a very good data. If you guys think you need compile or comprehensive judgments which is asked, or comprehensive cases, landmark cases of the Constitution, just make a comment in inbox. In which of the following landmark judgment, the right to privacy has been declared as a fundamental right? Very recent case, Justice K.S. Puttaswamy versus Union of India. I think nobody know, very rare person who is unaware. Correct answer is B. In the first instance, I am ready to answer this question. In which case the dissolution of Bihar Legislative Assembly by the governor before the formation of the government was declared unconstitutional? It's a state questions, and it's a Rameshwar Prasad versus Union of India. Now, a member of the State Public Service Commission can be removed on the ground of a misbehavior only after an inquiry has been held. By very famous question, and so many times it has been asked, only by the Supreme Court of India, on reference being made by the President. देख लीजिए, अगर मेंबर ऑफ द स्टेट पब्लिक सर्विस कमीशन को अगर रिमूव करना हो तो उसकी रिकमेंडेशन कौन करता है? प्रेसिडेंट करता है, और उसको द सुप्रीम कोर्ट ऑफ इंडिया करेगा, बट रेफरेंस कौन करेगा? प्रेसिडेंट ऑफ इंडिया. राइट टू फ्रीडम ऑफ अ रिलीजन कैन नॉट बी रिस्ट्रिक्टेड ऑन द ग्राउंड ऑफ morality, healthy, scrutiny, security of the state. Legal maxim artificius is related to very famous question again. It's a question number 109 ka W party. These are a very direct question. Carry forward rule is a ultra virus was held in the case. Very easy question. Devadasan versus Union of India. All these cases are landmark cases. The principle of a sovereign immunity will not apply to a proceeding for award of a compensation for a violation of a fundamental right. In which of case the Supreme Court of India held above? This case, the correct answer of a 1010 is your Rudal Shah versus State of Bihar. Which one of the following is not correct? Natural justice implicit in which one of the following is not correct? Natural justice implicit in Article 21. Right to privacy is a fundamental. Which one of the following? Right to privacy is a fundamental. Right to go abroad is not a fundamental. Right to life includes right to health. अब इसमें बोला कि कौन सा? Just think in your mind. Right to go abroad is not a fundamental right. This is your correct answer. According to A.V. Dicey, in India, the rule of law is embodied in which article of India? Obvious. Article 14. क्यों? क्योंकि इसमें सीधा सा अगर नॉर्मली अगर आप आर्टिकल 21 को पढ़ोगे तो वहां पे लिखा हुआ है नो वन इक्वालिटी बिफोर द लॉ और बाय द लॉ, मीन रूल ऑफ द लॉ. Now, administrative law is the study of a pathology of a power in a developing society, accountability of the holder of public power, or the rule is a local point of the formulation. Who among the following jurists has been give this definition? This is a Professor Upendra Bakshi. I don't know. I just looked from the answer key. Which doctrine of administrative law is a dilatory doctrine because of a many exception? I'm very weak in administrative law. I'm just copying it from the answer key. Answer is given A. Now, in which case the Chief Justice Ray said that the Constitution is the rule of the law and that no one can rise above the rule of law in the Constitution. जस्टिस रे की जजमेंट के हिसाब से क्वेश्चन नंबर 113 का करेक्ट एडीएम जब्बलपुर वर्सेस एसके शुक्ला दिस इज आल्सो अ वेरी फेमस case there are a bulk of a law which govern people and which come not from the legislature but from the chambers of the administrator. This is called delegated legislation and it is different from the 116. Correct answer is your executive legislation. Now the question number 114. Which of the following case is not related with the rule of law? ये भी है इंदिरा गांधी वर्सेस राज नारायण, बिल्कुल सही है। एडीएम जबलपुर तो अभी हमने डिस्कस किया। जय सिंह गांधी, करेक्ट आंसर इज योर सी। Delegated legislation must be controlled so that it can be properly delegated legislation must be controlled so that it can be properly exercised. What is the controlled delegation legislation? ये सब में पार्लियामेंट्री भी है, प्रोसीजरल भी है, जुडिशियल भी, ऑल ऑफ द अबव। ये these are the question of the administrative law. Now the test for question number 118, the test for determining bias is known as civil liability test, criminal liability test, reasonable likelihood, collective responsibility test. Correct answer of the 118 is your reasonable likelihood test. Now, which of the following doctrine developed by the court to control the administrative action in India? I think nowadays this is a very important. Actually, doctrine of promissory estoppel and doctrine of legitimate expectation, and this is your judicial activism. This is very important, and this is what on the basis of judicial activism, Supreme Court is doing a very important role. What is the effect of the violation of the rule of odi alter patrum on an administrative action? It's a very important, very easy. From the beginning of the law, we are studying this, and the correct answer is a null and void. A writ of prohibition cannot be issued against. Arre. Writ of prohibition cannot be against किसके? ये सिर्फ जुडिशियल बॉडी में चलती है, एग्जीक्यूटिव बॉडी में नहीं चलती है। Correct answer is A. Now the question number 125. In which of the following cases the Supreme Court held that the principle of a natural justice are applicable to an administrative proceeding also? It's again very famous case, and the correct answer is A.K. Karipak versus Union of India. Now the question number 128. Writ of quo warranto can be filed by? It's a very important. Quo warranto is the famous, right? And the correct answer is 128 is your any private person, whether aggrieved or not. There are the 5 kinds of a writ in our constitution. Article 32, which is known as the constitutional remedy. It's a detail. I can make a video if you want, write in inbox. The idea of the ombudsman was first suggested by who among the following? It's a Motilal Chimalal Setalwad. Now the question number 126. When reviewing the administrative action, the court's duty is to confine itself to the question of a legality. What are the ground for the judicial review? C. इसमें committed an error of a law or exceed its power, breach of a natural justice, both A and B. The action of an administrative tribunal is considered as a purely judicial. Guys, just think in your mind कि क्या होगा, क्योंकि ना तो ये प्रॉपर जुडिशियल बॉडी है और ना ही नॉन जुडिशियल बॉडी, तो इसलिए करेक्ट आंसर इज योर सी, क्वेसी जुडिशियल. करेक्ट. नाउ Mitakshara is a commentary on Manu Smriti, यजनवालक्य स्मृति, नारदा स्मृति, और commentary on यजनवालक्य स्मृति. Correct answer is B. It's not Manu Smriti, यजनवालक्य स्मृति. Marriage of a basically Mitakshara school is a school in which the compassionary concept has been arisen, and in most of the India there is a two types of school in Hindula. That is, one is your Dayabhaga and one is your Mitakshara. And Mitakshara is the Yajanwalakya Smriti, on the basis of Yajanwalakya Smriti. Marriage of a Hindu co-partner with a Hindu girl or with any other under the Special Marriage Act 1954 does have any effect on automatically so his membership of the बिल्कुल सही. It's a very important. Automatically सवर जो भी आपके जो benefits co-partner हैं वो जिस फैमिली से अगर उसने स्पेशल मैरिज एक्ट के हिसाब से शादी की तो आपके जो हैं जो आपके राइट्स हैं कुपाशनी प्रॉपर्टी में वो नहीं रहते. By the Hindu Succession Act, all Hindu women have become compassionate. Wife of the compassionate 9999. No, daughter of a compassionate has become a compassionate. This is the correct answer. Option number D. Question number 132. Now, question number 134. Pregnancy of a girl at the time of her marriage under the Hindu Marriage Act will not affect the marriage, will make the marriage ipso facto invalid, will be a ground of making the marriage, will be ground for making the marriage as a voidable. The correct answer 134 is your D. It's a ground of the voidable marriage. I think no. Spinda relation under the question number 135. Spinda relation under the Hindu law towards the fathers and the mothers side extend up to अरे फादर की साइड से 5 डिग्री और मदर की साइड से 3 डिग्री. तो correct option of correct answer of 135 is your C. Now the question number 137. Under the Hindu Succession Act 1956, daughter's son and father of a male Hindu are legally here. Daughter and they are placed as the following. इसमें लीगल हियर की बात हो रही है तो daughter son is placed as a class 1 and a father as a class 2 here of the schedule. सही बात है क्योंकि यार पहले बच्चे आते हैं, ठीक है, बच्चे के बाद फादर आ जाता है. A decree of a judicial separation passed by the competent court between the parties to the marriage brings the marriage relation between the spouse to the end. Does not affect the marriage relation but suspend the conjugal till the correct answer is your D. क्योंकि जो जुडिशियल सेपरेशन की जो डिक्री होती है उसमें आपकी मैरिज खत्म नहीं होती है बट उनको सेपरेट कर दिया जाता है, उनके जो मैरिटल रिलेशन है वो खत्म कर दिए जाते हैं. यही मीनिंग होता है जुडिशियल सेपरेशन का. जुडिशियल सेपरेशन जो है वो कोई डाइवोर्स नहीं है. जुडिशियल सेपरेशन जस्ट एक आपका वे है, एक रास्ता है बीच का पड़ाव है जिसको पास करके आपको डाइवोर्स मिलता है ऑन द बेसिस ऑफ जुडिशियल सेपरेशन. Marriage of a Hindu male or a female under the Hindu Marriage Act 1955. Marriage of a Hindu male or a female under the Hindu with a person of unsound mind or unsuffering mental disorder is not valid, voidable. बताइए जी, just think in your mind. What should be the correct answer? ये voidable marriage होती है. A child to be adopted under the Hindu Adoption and Maintenance Act 1956. Should be child belong to any religion, should be a child belonging to a Hindu religion and below the age of 15 years. बिल्कुल सही. अब हिंदू देखिए हिंदू अडॉप्शन की बात हो रही है, तो हिंदू अडॉप्शन देखिए, हिंदू है, हिंदू लॉ किसको एप्लीकेबल है? जो हिंदू हैं, और हिंदू की डेफिनेशन के लिए हिंदू होना जरूरी है, तो ये ऑप्शन तो नहीं होगा। तो हिंदू रिलीजन और जो 15 साल से कम होना चाहिए, देयरफॉर ये ऑप्शन, ये इसलिए नहीं होगा क्योंकि यहाँ पे 18 साल है, मे और मे नॉट बी हिंदू, तो ये तो होगा नहीं क्योंकि हिंदू में तो एप्लीकेबल है। देखिए, सो द करेक्ट आंसर इज बी। नाउ क्वेश्चन नंबर 141। A marriage prohibited under the Mohammedan law by reason of a difference of religion if done। अरे मोहम्मदन लॉ में देख लीजिए, मोहम्मदन लॉ का तो सीधा है इरेगुलर बोला जाता है इन मैरिज को। कौन सी मैरिज आती है? इरेगुलर। नाउ नेक्स्ट क्वेश्चन 140। Under the Hindu Marriage Act, a marriage is treated as a void if it contravenes the section given under 5A1 and 5(2) of the Hindu। देखिए, मैरिज void कब बोली जाती है? मैरिज void का जो है आपका, इसका तो सिंपल सी कंडीशन है आपकी कि जब ये आपका 5(1), 5(4) ये स्पिंडा प्रोहिबिटेड डिग्री 4 और 5 मीन में फॉल करती है, तो आपकी मैरिज वॉइड आती है। सपोज इसमें एक बड़ी अटपटी सी बात है कि अगर हिंदू मैरिज एक्ट में अगर आपने माइनर से शादी की है, तो वो शादी जो है आपकी वैलिड होती है, पनिशमेंट है उसमें, इनवैलिड नहीं होती है वो। तो मैरिज विद अ माइनर इज अ वैलिड मैरिज। एंड व्हाट बेसिकली जो फर्स्ट बात करता है कि नीदर पार्टी जो है, अगर फर्स्ट इसलिए वॉइड है क्योंकि आपके आपका जो फर्स्ट मैरिज जो हुई है, आप जो सेकंड मैरिज कर रहे हो और उसकी आपके फर्स्ट वाइफ के होते हो या हस्बैंड के होते हो, आप दूसरी मैरिज कर रहे हो, तो इसलिए वॉइड होगी। ठीक है। और जो फोर्थ फिफ्थ इसलिए वैलिड इनवैलिड सॉरी वॉइड है क्योंकि आपने जो है प्रोहिबिटेड डिग्री और जो है स्पिंडा में आपने शादी की। ठीक है, इसलिए करेक्ट ऑप्शन इज योर डी। नाउ 142। According to the Section 4 of the Dissolution of a Muslim Marriage Act 1939, apostasy from Islam or Muslim by 142, the correct answer is your B, will not dissolve her marriage ipso facto. Okay. Now, which of the following is not essential for a valid gift or a hibba under the Mohammedan law? अरे कहाँ पे रिटर्न की बात होती है? वहां पे रिटर्न डॉक्यूमेंट्री प्रूफ ऑफ द गिफ्ट। अच्छा, who under the Mohammedan law can claim a right of a preemption? इसमें कोशेर नहीं, साफी किल्लत नहीं, all of them, all of them, they can claim the right of the preemption. Now, 144. Which one of the following is the leading case under the Mohammedan law on a widow's right to retain possession of her husband property? Really a very landmark case. You must remember, and I recommend ki you have to go through this case because it changes the life of the Muslim women. Maina Bibi versus Chori Bakil Ahmad. In favor of a who among the following bequest by a Muslim is a ballot. मतलब in favor of a who among the following जो है, अगर bequest मतलब bequeath करेगी मुस्लिम by a Muslim is a ballot, bequeath करेगा मुस्लिम तो ballot मानी जाती है। तो correct answer of 146 your a grandson in case of a predeceased son कर सकता है वो। These are some basic family law question of the Muslims. In case of a buck, this is a buck fact. In case of a buck, the property based in the buck, Mutaballi Almighty. Correct answer is your Almighty. In the Sunni law of inheritance, the total number of a share is no. 12. Correct answer is 12. Now, by the third pronouncement utterance of a talaq, which kind of a talaq become talaq-e-hasan, talaq-e-hasan, talaq-e-tafweez, none of the above? The correct answer of question number 148 is your talaq-e-hasan. These are the form of the talaq. if you read the talaq in the Muslim, talaq e hasan, talaq e ahsan, talaq e biddat, तो वो instant triple talaq जिसे बोलते हैं. Who is the correct answer of the 148 is your A. Who is the primary here under the Sunni law? Primary here is my grandfather, none of the above. Correct answer is none of the above. So this is all about the Bihar Judiciary exam. So please, if you now it's a series, state by state, I will upload the all exams with little discussion. And if you want the detailed discussion, please comment. Definitely, I will consider your point. Thank you very much.